Good morning, everyone, and thank you for joining us. My name is Matt, and I'm here with my colleague, Louisa.
Good morning, everyone.
We have over 2,000 people registered for today's webinar, which goes to show the significance of our topic, hot topics in human rights. The format for this morning is as follows. We will present from 9 a.m. until roughly 10 a.m. and then answer questions until about 10:30 a.m. If you have a question, please type it into the Q&A box on your screen. So that's the Q&A box and not in the chat box, which should be disabled. We'll do our very best, as always, to answer as many questions as we can. And if we can't get to your question, please reach out to us after the presentation and we'd be happy to connect and help you with your question. Finally, a recording of this presentation and the slide deck will be available on our website in a day or two. So with that intro out of the way, let's get started. Here's our agenda for today. So we've grouped our topics into 4 different areas: racial discrimination, sexual harassment, human rights in the unionized workplace, and accommodation roundup. And some of these issues are probably the most hot button topic issues and the most calls that we're getting from employers in the recent months. And I think what's great about this presentation is it's going to be very heavy on the case law. And why I think that's great is we'll go through some real life recent examples on each of these topics, and they provide us with some great takeaways and lessons for employers about what to do, and in some cases about what not to do. I'll also add the last point there under accommodation round point. We'll be focusing on family status, disability, and religious accommodation. And I think, at least from my own personal experience in the last little while, as things have basically become, reopened and we're back to what our new normal is, family status and disability and attendance management are really 2 of the biggest issues that we're seeing with our employer clients. And so we're going to walk through those, and we've saved those for the end. It's a little presentation tip, most interesting and maybe most important topic at the end to make sure that everyone sticks around as engaged for the entire presentation. So with that, I'm going to kick it off by talking us through the topic of racial discrimination and a couple of new cases that have maybe changed the lens in which our courts and tribunals and adjudicators are going to be looking at how they assess potential issues of racial discrimination in the workplace. The starting point to establish discrimination, and this is on the basis of any protected ground under your provincial human rights code. So it could be race, it could be sex, it could be family status, it could be disability, for example, is first the claimant or the individual or the applicant must establish that they are a member of the protected ground, that they've suffered adverse treatment, and that their protected ground was a factor in the adverse treatment. And as you can see on the slide there, we say the last point can often be a challenge for a claimant in the cases of racial discrimination, but some of these cases that we're going to talk about maybe change that a little bit. But the key point there is you heard me emphasize the word a before factor. So a factor. It doesn't necessarily mean that the protected ground has to be the only factor in the adverse treatment, the key factor, the most important factor. It's sufficient for the applicant to establish that it was a factor in the adverse treatment. So that's something that's very important for us to keep in mind as we're going through potential accommodation analysis or going through a decision about whether or not we're going to terminate an individual, whether or not there are factors or a factor in the workplace that could potentially expose us to a risk of a human rights complaint or a human rights allegation within a court action or a grievance, for example. With respect to racial discrimination, it's rarely overt, right? So it's not often you're going to have sort of that smoking gun, right, to establish overt racism. More often than not, it's established through circumstantial or indirect evidence and perhaps multiple examples or multiple pieces of evidence to point to the fact that there may have been racial discrimination in the workplace or part of a decision made by the employer. And the recent cases that we'll talk about in a second provide some examples of what this evidence may look like and how the broader social context may be relevant. And so it may not just be enough anymore for employers and decision makers to look through just sort of the lens of the workplace, but these cases suggest that perhaps some broader contextual and social factors may also impact the analysis that a decision maker is going to undertake. The first case that we're going to discuss today is a case that comes from the Ontario Labour Relations Board. And you'll see there it's between LiUNA, Local 183 is the union, and Crosslinks Transit Solutions is the employer. And what this employer does, or was doing at the time that this grievance was filed, was that they were helping build the stations for the Eglinton Crosstown, the light rail train system. And the griever had worked for approximately 2 years for this employer at a few different projects. And ultimately, he was terminated for just cause after 2 specific workplace outbursts. So the termination was based on these 2 specific workplace outbursts. And the individual, the griever in this case, was a Black man. And on the first occasion that the employer relied upon, the griever went away for vacation. And when he had left for vacation, he had changed the lock on his toolbox. And he had, instead of using an employer issued one, he used one of his own. And when he came back, he saw that the lock was completely cut off and that somebody had gone through his tools while he was gone. I think understandably, he was quite upset that this happened. And he had a bit of an outburst and a bit of a, we'll call it a yelling match or a heated confrontation with his supervisor about this. And then he was issued a written warning 1 month after the incident occurred. So, as we're looking for small takeaways from some of these cases, if we're looking at what maybe the employer did wrong in this specific instance, generally speaking, waiting 1 month to issue a written warning for something like this is probably, too long. So if you do find yourself in a situation where discipline may be warranted, you don't want to rush to implement it, but you want to probably act more quickly than they did here in this case. So that was the first incident. And when we got to the evidence before the labor board about this incident, there was sort of some inconsistent explanation from the employer's witnesses about why exactly they needed to go into the toolbox. So they didn't really have a good specific reason. And that played, a part in the decision, as we'll get to a little bit later. The second incident occurred 6 months after the first. And in this case, the employer alleged that the griever failed to respond to a radio call. So he was operating a radio on this specific construction site. The griever claimed that the radio did not work, right? And he actually went so far as to say, I think maybe I was set up, that I was provided a radio that was not working so that I would fail and could get in trouble. And as they were dealing with this, he later got quite upset. He felt that he was singled out for the incident. And there was a meeting in the supervisor's office in the construction trailer, where, again, there was a bit of a heated confrontation, and he allegedly banged his fist on the table and was yelling at the supervisor. Again, when this was what the employer relied upon in their termination letter and as part of the reason for the termination for cause. But once we got to the hearing and it was time to provide evidence, the decision maker, the vice chair of the labor board, found that there was inconsistent evidence about what had happened in that meeting. There was inconsistent evidence about, what exactly happened with the radio. The employer had the supervisors and managers that were involved as witnesses had signed witness statements. And the vice chair found that there was some critical pieces of information that were missing. The other piece here was he was terminated for cause 10 days after the incident. So again, probably a little bit longer than we would typically see in this situation, even if you're doing an investigation into the misconduct. And following the termination, the union alleged that the conduct did not amount to just cause, and also alleged that the termination was discriminatory. And so the decision maker, the vice chair, was forced to do 2 separate analyses in this case. 1, was there just cause? And 2, was the termination discriminatory? As part of their argument that the termination was discriminatory, the union called an expert, a professor of psychology at York University, to testify about the impact of implicit bias or unconscious bias. And I think her evidence basically went in untested. So the employer didn't have their own expert. The employer didn't challenge her credentials. And what happened is the expert evidence testified that implicit bias is the belief that members of outgroups are different from members of an in-group, and that racial bias is a type of implicit bias. And her study and her report specifically found that there's a large majority of individuals who show an implicit anti-Black bias, and that common traits unconsciously associated with this implicit bias with Black men is that they are loud, threatening, aggressive, and hostile. And in considering her evidence, part of what the expert testified was that the research suggests that oftentimes when somebody makes an allegation or accusation of racism, the research suggests that the person who's accused of the bias may not believe the assertion because they perceive themselves to be acting in a fair and egalitarian manner in accordance with their explicit views. And so based on this evidence, the vice chair at the labor board held that her evidence explained how decent, fair-minded people who would eschew and denounce racist conduct might still act on unconscious biases to the detriment of an outgroup and to the benefit of the members in the in-group. This is what I believed occurred in this case. So this goes back to the beginning when I said, rarely do we see overt racism, and oftentimes it's circumstantial evidence. And that's exactly what the expert testified here is, you're not necessarily going to have that smoking gun where there's a one-off egregious incident of racism, but oftentimes there may be things that are present that individuals who are involved may not necessarily be aware of that do equate to discrimination. And so ultimately in this case, the vice chair held that there was no just cause to warrant termination, and also held that the termination was discriminatory. The reasons being the griever was assumed to be in the wrong, whereas non-Black employees in similar situations had had their conduct attributed to external factors. So the vice chair there found that there was maybe some differential treatment between the way this griever was treated and other individuals had historically been treated in the workplace. And they also said that the conduct was seen to be a threat to employees' health and safety, but no employees found it threatening at the time. So again, sort of back to some of that inconsistent evidence. Another key piece in terms of why the employer was unsuccessful in defending just cause, and why the union was successful in proving discrimination, is that the termination letter, right? So sometimes termination letters can be a bit of a blessing and a curse. In this case, it probably fell into the latter category because it was very detailed, but the termination relied on things in the letter that ultimately the vice chair did not find to be persuasive. For example, the termination letter relied on instances of the griever's behavior in the past that he was never disciplined for before, but they threw it in the termination letter. The termination letter referenced to employees fearing for their health and safety, but there was no evidence to support that. And so those are just a couple of examples of when we're drafting our termination letters, we want to be careful that we're not including something in there that we won't be able to successfully rely upon, because ultimately that's going to be the first thing that a decision maker looks at, and the standard that we may be held to. And so ultimately, with respect to discrimination, what the vice chair concluded here was, look, this wasn't a workplace that was rampant with racism. It wasn't a situation where there was an egregious conduct, but that the griever was subject to more nuanced forms of racism and discrimination in the workplace. And ultimately, that's why the vice chair found the way he did. The next case comes from the Alberta Human Rights Tribunal. And in this case, the complainant worked as a nurse in a correctional facility, and she was an Indigenous woman who had attended a rally, and it was a rally around Indigenous rights following the acquittal of a white male following the murder of an Indigenous woman. And she was holding a sign that said, "White people scare me." And what happened is a coworker or group of coworkers found this photograph of her holding the sign saying, "White people scare me," and it was distributed around the workplace. So it was posted in certain areas. It was on computers. People were, kind of laughing about it, making snarking comments about her. And so it became quite prevalent within this workplace. And in response to the complaint made by the employee, the complainant was placed on a paid leave of absence. And the justification for the employer was, well, we're afraid for her safety now in the workplace because she's been subjected to her threats and abuse. And they offered her to return to work, but in a different role, more segregated role, where she wouldn't be around the other employees. The individual here said, well, I'm not going to come back to work in that different role, and filed a human rights complaint based on her treatment. At first instance, this was considered by the Alberta Human Rights Commission, and they dismissed the complaint. They found that the employer responded appropriately. They looked at it and said, well, look, this does seem like a health and safety incident, so we think it was right that you put her on a leave to protect her safety. And then the complainant filed the request for review with the Alberta Human Rights Tribunal. At that tribunal, the respondent argued that the adverse treatment was related to her conduct attending the rally and holding the sign, not her race. So they tried to separate their decision-making from her race and again, point to some potential misconduct from the rally, and based on her health and safety, they tried to justify her decision. But the tribunal dismissed this and they overturned the initial decision. And this is where some of that social context comes into play. So what happened here was they found that the employer and the commission who reviewed the complaint at first, they took too much of a segmented analysis, right? So they just took too much of, like, maybe we can frame it as tunnel vision, looking at the intention of the employer. Oh, they wanted to protect her health and safety, so this was the appropriate thing to do. But what the tribunal here said, what they ought to have done was understand and look at some more of the temporal and social context undermining the complaint. So for example, this Indigenous woman, the complainant, was a survivor of the residential school system. She had recently attended this rally that I spoke about. Other non-Indigenous employees who may have been subject to the same type of treatment in the past for various reasons, like harassment, for example, were treated differently. She would put up posters in the workplace that they were torn down while other posters weren't. So ultimately, the tribunal here said, for a proper analysis, you've got to consider the entire social context underlying the complaint, and not just sort of the specific, maybe the specific facts within that workplace. And so here were some of the facts they considered. Like I said, she was an Indigenous woman subjected to workplace threats and labeled racist because she was protesting historic bias against Indigenous people. And the tribunal held that this was sufficient for the complaint to proceed on the hearing on the merits. So ultimately they said, the commission, you were wrong with your decision. We're going to go back and let her advance her complaint. So the takeaways here before I flip it over to Louisa: consider how we may want to take some steps to reduce the impact of bias in disciplinary decisions. For example, implicit bias training, diverse management teams. And in the case of racial discrimination, make sure that we're critically evaluating the circumstantial and contextual evidence, because we're not going to find that smoking gun. So just because there's an absence of that overt racism, I think we think back to the labor board's comments in the case that I just discussed, that it may be more nuanced. That's the analysis that we want to take to ensure that our decisions to terminate are free from race playing a factor in our decision to terminate. And now we'll hand it over to Louisa, who will walk through the sexual harassment cases.
Thank you, Matt. And hello again, everyone. My name is Louisa. I'm so glad to see so many of you joining us here today. We're going to take a bit of a turn now away from the cases on racial discrimination, and we're going to look at some of the recent developments in the law with respect to sexual harassment. For the next portion of the presentation, I'm going to be walking you through two key cases that came out of our Court of Appeal for Ontario, and that specifically dealt with sexual harassment. These decisions expressly consider the issue of when sexual harassment amounts to just cause for termination, and perhaps go a bit further to consider the question of, if it does amount to just cause for termination, is it also the case that it'll meet that higher threshold of willful misconduct under the Employment Standards Act? And we'll unpack what that means and the implications of that in just a little bit. So let's turn to our first decision of Husko and A.O. Smith Enterprises Limited. This decision came out just last year from the Court of Appeal and dealt with an employee who's a project manager. She's a female, and she made a complaint that she had been sexually harassed by the respondent, who's a senior product designer with 20 years service. Essentially, the employee said that she'd been subjected to a series of inappropriate comments that were made by her male coworker. These included what you see up on the slide there. So for instance, he asked her if she danced on tables at a work event, which she interpreted to mean whether or not she was an exotic dancer. At one point in a group meeting with other male colleagues, this employee told her that she needed to sit on a coworker's lap while figuring out a difficult problem. In a separate conversation about gardening, there was a reference made to the employee going down on her knees, which she again later testified that she understood to be a sexual act. And lastly, the employee made a vulgar reference to her being on top of a list. And what was particularly egregious about that last comment was that it was also accompanied by some inappropriate and sexually suggestive physical gestures. So the female coworker, understandably filed a complaint, and the employer investigated the complaint and found that the complaints were substantiated, in part because some of those comments had been witnessed by other coworkers. The male employee just remained adamant that this was all taken out of context, that it was simply a misunderstanding, and that she read too much into the comments. The employee ultimately was asked to look at a number of terms that the employer wanted to implement so that going forward, they could manage the relationship between the male and female coworkers. And so they asked the employee to undergo training, sensitivity training, and to apologize to his female colleague. The employee, again, remained adamant that he'd done nothing wrong. He said that in reference to that last incident with the physical gestures, he explained that away as he was in a chair and the chair was stuck in the carpet and he was physically moving himself so as to free himself from a rut in the carpet. And again, just maintained adamant that this was all a misunderstanding. The employer, not surprisingly, found that the complaints, again, were substantiated. And so the employee agreed to do the sensitivity training, but he ultimately refused to apologize for his conduct. So as a result, the employer concluded that that employment relationship was no longer tenable and terminated the male colleague for cause. So what happened next? The employee filed a wrongful dismissal suit. And at trial, the judge reviewed the comments that were made as well as the response to the investigation and found that this didn't amount to just cause for termination. The trial judge found that this really just looked like a misunderstanding between two employees that had a conflict in their working relationship. The trial judge put a lot of emphasis on the fact that this employee was essentially terminated as a result of not apologizing. The employer appealed the decision. It went up to the Court of Appeal and the Court of Appeal overturned the trial judge's findings and found that, yes, actually this conduct did amount to just cause. And importantly, the Court of Appeal looked at it and said, you know what, the refusal to apologize was ultimately only a part of the reason why this employee was terminated, but it wasn't the sole reason. The comments that were made by this individual were undoubtedly sexual harassment. The Court of Appeal reminded that sexual innuendos and comments do constitute sexual harassment. And more so the fact that the employee had been trained on the employer's workplace harassment policy and understood that such conduct could result in termination took away from, I think, part of the employee's position in this decision. And ultimately, the employee just remained adamant, even at this stage, that he was unwilling to accept accountability for his conduct. So the court, again, reminded that in the just cause analysis, an employer has to consider and balance the severity of the misconduct and the sanction imposed. So at the risk of oversimplifying, essentially, does the punishment fit the crime? And so in balancing this equation, the Court of Appeal held absolutely the employer's decision to terminate the respondent's employment was a proportional and wholly warranted response. The employee just remained adamant, didn't understand the seriousness or the severity of his actions, and he just refused to comply with ultimately what were reasonable and essential requirements for an apology. The Court of Appeal also commented that there was no requirement for the employer to have negotiated with the employee as to the terms of how an apology could have been made, for instance, whether it could have been made in writing, which is something that the trial judge had remarked. So that takes us to the end of that decision. And we're going to look now at one more that's more recent and came out this year, Render and ThyssenKrupp Elevator Canada Limited. So this decision dealt with an operations manager who had 30 years service, a male manager. He was in the midst of joking around with a female colleague about differences in their height. He was invading her personal space and ultimately took it a step too far when he actually slapped his female coworker's buttocks in front of a group of male colleagues. He later went even further and joked about it with his male colleagues, offering to be paid $10 for whoever wanted to touch his hand after the incident. So unsurprisingly, the female employee reported this to HR. The employer conducted an investigation, found that the complaint was substantiated, and terminated this individual's employment for cause. The employee filed a wrongful dismissal, and at the trial level, the trial judge upheld the termination for cause. The trial judge made a number of interesting comments. So trial judge noted that there wasn't a reporting relationship between the male and female colleagues, although this is sometimes something to keep in mind in the analysis on sexual harassment. However, the trial judge did note that it was a relatively small workplace. There were about 10 men and 3 women in the office. And this was an environment of kind of regular joking and office banter, which we often see. And the operations manager, the respondent in this case, actually gave evidence that he encouraged a joking environment so as to try to reduce stress in the office, which is something we often see. However, the trial judge said that this went a little bit too far and that there was a lot of suggestive and sexually suggestive banter going on in the workplace. And ultimately, again, we're seeing a repetition here. The male colleague just didn't appreciate the severity of his actions and ultimately why it amounted to sexual harassment. The employee appealed, and on appeal argued that, you know what, a less severe punishment would have been fitting in this case. So for instance, a suspension. And ultimately, even if the conduct did constitute just cause, it didn't meet that threshold of willful misconduct so as to disentitle him from his minimum standards under the Employment Standards Act. And just as a brief recap there, we'd be looking at things like termination pay and for certain eligible employees, severance pay. So what ended up happening at the Court of Appeal is that the Court of Appeal confirmed the conduct was just cause at common law, and importantly noted and reminded, similar to a decision that it had actually decided about 25 years ago in Bannister, that this kind of office environment can't be used as a mitigating factor. It's just not something that's really ever been tolerated, and it certainly can't be tolerated today. However, it did allow a narrow appeal on the issue of whether or not this individual was entitled to his entitlements under the ESA. And so on that point, the court noted that with respect to willful misconduct, it's really a higher threshold than just cause. It requires something a little bit more in terms of there being knowledge and an intent to do wrong or to cause harm. And when looking at this incident, the Court of Appeal found that it was something that was very much in the heat of the moment and somewhat spontaneous. There's a great line in here, at most a deer in headlights, freezing of intellect. So ultimately, the court found this didn't constitute willful misconduct because there was no real element of kind of pre-planning or premeditation. And so as a result, because we're talking about a 30-year service employee, he was entitled to the maximum termination pay of 8 weeks under the ESA. And the question of severance pay was actually a separate issue. He argued he was entitled to 26 weeks, which is the maximum under the ESA. But because there was no evidence led to support that the employer was a severance paying employer, i.e. that it had a payroll of $2.5 million or more, the employee didn't qualify for that additional severance payment. So what are some takeaways from all of these decisions that we can kind of go forward with? An overly casual workplace is just not an excuse for inappropriate behavior. And more so, it's important for employers to recognize that there's a positive obligation to take reasonable steps to prevent that kind of harassment in the workplace, which might mean checking in to see if you do have that kind of office culture. Certainly, it's understandable that lots of employees want to joke around in the workplace, but just making sure that, it's not crossing the line into gray territory. Similarly, an employee's conduct post-harassment is relevant to the assessment of just cause. Remember that when we're thinking about whether or not termination is appropriate, we want to see how likely is it that this employee has learned about the severity of what they did and that the punishment imposed would fix the issue. If suspension is let's say, the discipline that's chosen, if this employee came back to the workplace and just didn't understand that, the misconduct amounted to sexual harassment, is there a chance this employee could reoffend? And so that's something that we want to consider because it's certainly taken into account with respect to the analysis. And lastly, even if the harassment constitutes just cause, you want to keep in mind that the employee might still have statutory entitlements to termination pay and in some cases severance pay if that conduct occurred kind of in the heat of the moment. We don't suspect that argument will fly very much with respect to a series of incidents, kind of like a series of comments that have been made, especially if that employee had been warned on multiple occasions that conduct just wasn't welcomed. It's likely only going to apply in the instance of an isolated incident, like that last case that we looked at. So next, I'm going to turn it back over to Matt, who's going to look at the question of what it looks like to file a human rights complaint as a unionized worker.
Thanks, Louisa. And keeping with some of the theme of this presentation, I'll be talking mostly here about one case, a Supreme Court of Canada case, and just fair warning, it's not as interesting as some of the other cases that we've talked about so far from a facts perspective, and some of the other cases we'll talk about after this section. It's about jurisdiction, right? So I know you're like, oh, boring jurisdiction, but just trust us, it's an important case to consider, and extremely interesting one for law nerds like ourselves. But so historically in a unionized environment, and some of you may be familiar with this in your own respective workplaces, when a human rights issue arises, somebody could file a complaint either with their provincial human rights body, so to their provincial human rights commission or the tribunal, or file a grievance under the collective agreement through their union. But there's a recent Supreme Court of Canada decision that says that this is no longer the case in at least one Canadian province, and sort of leaves the door open for whether or not this may be the case in other provinces. So the case comes out of Manitoba. And again, the facts here really aren't all that important because it kind of, the takeaway is this narrow issue of jurisdiction. But it was a unionized healthcare employee that was terminated for a breach of a last chance agreement related to alcohol addiction. And I think we're all likely familiar with the case law on alcohol or substance use issues, that it is considered to be a disability and are protected grounds under provincial human rights codes. And so ultimately here, the individual filed a human rights complaint alleging discrimination on the basis of disability. But the issue to be decided through the commission was whether or not the commission had jurisdiction to hear the complaint. So should it have gone to the commission, or should it have been filed through a grievance procedure and this employee's union because she was unionized? And it went all the way up to the Supreme Court of Canada, right? So I told you there's some interest in jurisdiction. Our highest court weighed in on this, and it held that the commission did not have concurrent jurisdiction over a human rights issue within a unionized workplace. And so ultimately what the court decided was that the human rights issue that was raised was the exclusive jurisdiction of a labor arbitrator, given the language of the Manitoba Labor Relations Act and Human Rights Code. Now, because we're nice, we've spared you sort of the nitty-gritty analysis under the Labor Relations Act and under the Human Rights Code. But the key point and takeaway here is in Manitoba, and what the Supreme Court says to do for other provinces is they really looked at the two specific schemes and did a statutory analysis under those acts to determine whether or not in Manitoba this concurrent jurisdiction existed. And so right now, what the takeaway here for employers is that in Manitoba, a unionized employee must use the grievance procedure to litigate employment-related human rights issues. So it can't go through the commission, it's got to come through a grievance through the union. And again, if and how this case may be applied in other jurisdictions remains to be seen. Like I said, it depends on the statutory language in the province that you're operating in, or if you're federally regulated. The comments from that case from the Supreme Court of Canada suggest that concurrent jurisdiction, so the ability to file either through the commission or the tribunal or through the grievance procedure, will continue in British Columbia and federally at least. but the court didn't really provide any more, sort of nuggets or tips for any other provinces. With respect to Ontario, we don't have a decision yet from the Human Rights Tribunal or courts that directly address this issue. So nothing directly on point to provide some strict guidance on whether or not there still is concurrent jurisdiction, or whether or not this will be the exclusive jurisdiction of a labor arbitrator through the grievance procedure. However, we do have some earlier Ontario Court of Appeal decisions that suggest concurrent jurisdictions remain, meaning we would probably say the current state of the law is that they could file either through the tribunal or through the grievance procedure, but it remains to be seen whether or not an employer may want to challenge the ability to go through the commission or the tribunal, for example, and try to use this new Supreme Court of Canada decision as authority to suggest that's appropriate. So the last point there is stay tuned. We'll keep you posted on if anything changes in Ontario. And so with that, wanted to get through that quickly so we have time to go through what I had promised at the beginning of the presentation would be the most interesting topic, and it's walking through accommodation issues dealing with family status, disability, and religious claims related to the COVID-19 vaccination. So back to you, Louisa.
Great, thank you, Matt. So yep, as Matt said, we're going to be looking at an accommodation roundup of decisions. We're going to be looking at family status claims that relate specifically to childcare, disability claims that relate to excessive absenteeism, which is definitely something we've been seeing quite a bit of. And then lastly, we're going to be looking at, and Matt will be walking us through, religious claims related to COVID-19 vaccination, which is definitely a hot button topic. So with that, we're going to start with family status, and we're going to look at our first decision of Coven Tharaja and Paragon Linen Laundry Services, Inc. This was a decision from the Human Rights Tribunal of Ontario that came out last year. This decision dealt with an employee who operated a large commercial washing machine for the respondent's commercial laundry service, which the HRTO later found was a skilled technical position and accepted that there were very few employees that could do this job. The employee lived with his spouse, his elderly parents who had quite significant health issues, and 3 children that were all under the age of 6. And as a result of the 3 children, it was always the case that either the employee or his spouse needed to be at home to watch the children because the elderly parents, because of their health issues, simply weren't in a position to watch the children for more than, a few minutes at a time. So when their youngest child turned 1, the employee's spouse decided she wanted to return to work, but ultimately was only able to find work on an evening shift that had a 3 o'clock start time. This posed a bit of a challenge because the employee's regular hours were 8 a.m. to 4 p.m. So as a result, the employee requested accommodation from the employer and asked for his hours to be rescheduled from 6:30 a.m. to 2:30 p.m. The employer granted this accommodation request, but for some reason, about a year later, revoked the accommodation without any real notice to the employee and stated that, in an effort to increase efficiency with respect to running its business, it was now going to require that all employees work the hours of 8 to 4 without exception. Unfortunately, the employee spouse wasn't able to secure accommodation in her workplace until much later. I think there was evidence to show that about 3 months later, her accommodation request was finally granted. But this was unfortunately too late for this employee who had to continue to leave work at 2:30 p.m. every day. And so as a result, he was given multiple notices and the employer finally terminated his employment. At trial, there was some dispute about whether or not the employer had actually given him the opportunity to reschedule his shift to a morning shift, which would have ended in the afternoon prior to terminating. I think ultimately the HRTO found that that offer hadn't actually been made to him at the time. And so as a result, the tribunal found that the employer did breach its procedural duty to accommodate by failing to engage in that conversation with the employee about what a suitable alternative might look like with respect to the employee schedule. There was also some evidence, interestingly, presented at the hearing that suggested that the employer tried to accommodate after the fact. So after having terminated, the employer apparently tried to call the employee back to work and did start engaging in that conversation. The tribunal made some interesting findings there and said that although that evidence certainly can be taken into consideration, it wasn't determinative, however, of the fact that the employer had breached its procedural duty prior to imposing discipline. So what happened? The employee was awarded 13 months of lost wages, which was something around $29,000, and another $20,000 for injury to dignity, feelings, and self-respect as a result of the breach. The employer argued that its position in all of this was that the employee failed to provide evidence that they had actually considered alternate care arrangements for their children. And the HRTO took note of that, but ultimately commented that, and this is a helpful reminder and I think a practice point for us to pause on for all employers, and that's the duty to accommodate really requires a conversation between the employer and the employee. It's to look at that dialogue of what are the limitations, what are the possible solutions. It's an opportunity to get creative and look for something that works for both parties. And so ultimately, because the respondent didn't engage in that dialogue for looking for some sort of alternative, it didn't even come up or present the opportunity for the employee to have engaged in that analysis to look for alternate care arrangements. And so the conversation was shut down before any solution was ever found. And so as a result, you'll see that quote there up on the next slide. You'll see exactly as I just mentioned, had the respondent engaged in that dialogue in the circumstances, I find the applicant, it would have been appropriate for both sides to engage in that exploration of alternatives. But again, that was stunted by the failure to engage in that dialogue. So we're going to turn next to a different decision, which had a different outcome. And that was the City of Toronto and QP Local 79. And that's more recent. That's this year. And it's an Ontario labor arbitration decision. In this decision, the employee was a caseworker who had been off on a medical leave, and it was quite extended. And then upon her return from the medical leave, and we often see this is the case, wanted a return to kind of her terms of scheduling when she came back. And part of that was to account for her younger children who'd be dropped off at home from school from the bus, and she kind of thought the children were too young to be alone. The children were 10 and 6 years old. And so ultimately she said, they weren't in a position to afford aftercare from the children's private school. She also stated, they weren't actually the ones paying for the children's private school. This was something that was being paid for by extended family. Their spouse or her spouse didn't reside in the home and actually couldn't meet the children because of work commitments. And she also provided evidence that really no family members could meet the children. So the respondent actually granted her accommodation request to move her hours from 8 a.m. to 4 p.m. to 7:30 to 3:30 p.m. But this request was granted on a temporary basis. And after the accommodation request was granted initially, the supervisor forwarded formal documents that the griever had to then fill out to substantiate her request, including a request for documents to demonstrate financial difficulties and why she needed this accommodation request granted. She provided all kinds of documents, including the cost of busing versus the cost of after-school care. She also provided quite extensive financial information because the employer pushed back on that initial production of documents and asked for more. So she provided tax information, mortgage information, bills. She actually expressed embarrassment at one point because she disclosed through her supervisor to the employer documents demonstrating a substantial amount of debt that they were in, including costs incurred for marriage counseling and bank account information, just to give you a general idea. Ultimately, the employer still denied the request because there was some inconsistency in the way the employee had been characterizing their financial hardship, as well as what was or wasn't suitable. The employee grieved the fact that her accommodation request was rejected. And the union argued the fact that the employee hadn't exhausted all of the self-accommodation options wasn't a bar to establishing prima facie discrimination. The employer took the position rightly that, this was a request that was a preference and not necessarily one that was a need. And so when the arbitrator took note of all of this and considered the fact that there were other supports available, this did form part of the prima facie discrimination analysis, but ultimately held in reviewing the law that there was no requirement for the employee to exhaust all of the self-accommodation options prior to that. However, if there are readily available reasonable alternatives, that can weaken a claim of discrimination. So in this case, what were those readily available reasonable alternatives? Well, when looking at the information, the arbitrator found ultimately the cost of after-school care was quite comparable to the cost that was already incurred of busing the children home. Also, there really wasn't any exploration of options such as babysitting, which could have been something that was less expensive. And I think one of the key things that the arbitrator kept highlighting was that there seemed to be this insistence from the employee that they couldn't incur any costs, not even a smaller portion of costs. And so ultimately, the arbitrator dismissed the claim of discrimination. Something of note, though, is with respect to all of those documents that I highlighted a bit earlier, the arbitrator actually awarded $1,000 for breaching the employer's policies and procedural obligations under the code as a result of the fact that that employer requested quite private documents. And I think particularly what was challenging about this was that those documents were flowing through the supervisor, and the supervisor was privy to all kinds of information that maybe perhaps overstepped the bounds of what would be considered the employee's privacy and dignity. And ultimately, the arbitrator held these things could have been avoided. So in looking at all of these cases, what are our takeaways? As with any case of accommodation, it's always important to remember that there is no right to preferred accommodation. It's really going back to that earlier commentary, a matter of dialogue, exploring all the options and looking at what options work for the business, as well as ultimately address what it is that the employee needs or requires for accommodation, rather than, perhaps their preference of starting a half hour later or ending a half hour earlier. And ultimately, if there are other childcare options that are available, that is a relevant factor that's considered as to why they may or may not have been explored. And as well as we saw in that last case, it's important to remember that if you are collecting sensitive information for the purposes of rightly establishing whether or not there is a need for accommodation and how to accommodate, it's important to consider how that information is being collected. So for instance, if there's an AUC health department, considering whether or not that might be a more suitable forum to collect that kind of information so that it doesn't exchange too many hands or is seen by too many people. So with that, I think we'll now turn to disability. This decision, the TTC and ATU Local 113 came out this year, and the TTC in this case was actually represented by two of our colleagues, Shayna French and Natasha Zervoudakis, who successfully argued that an employee's termination for innocent absenteeism should be upheld. The arbitrator reviewed a total of 197 instances of absenteeism, which totaled 483 days. And when looking at all of this, found that this employee who had 13 years service had actually been absent for a total of 2 years out of those 13 years of service. The employer was actively managing those absences through an attendance management program that was found in the collective agreement in terms of the substance and the form of it. Many of these absences related to a medical condition. The griever initially had some trouble substantiating that medical condition with documents, but was ultimately later on able to substantiate it. Some of those instances of absenteeism related to things totally unrelated to the medical condition. They were just things like, he decided to prioritize staying home because his family had needs or what have you. So as is the case with absenteeism, it's rarely ever clean cut, and it's hard to it's very fact specific, lots of stuff going on. So in sorting out all of those absences, the arbitrator found, it was all relevant to the analysis and accepted the employer's position on that, but ultimately looked specifically at those absences that were related to the medical condition, and specifically it was an allergy. Something that was really important to note in this decision was that the griever was one of only 2 blacksmith welders that were employed by the TTC. And so when we're looking at that duty to accommodate and an employer's duty to accommodate to the point of undue hardship, this factor actually played in quite a bit to that analysis, because what ended up being proven with the evidence is that, because this griever was away so often, it required him working extensive hours of overtime when he did return, or it created a requirement for his other coworker, the only other blacksmith or welder, to also work a substantial amount of overtime. So it posed a lot of operational constraints on the TTC's operations. The griever was told repeatedly through the attendance management program, through a number of meetings, all of which were documented and notes were provided, that continuing on in this fashion just wasn't sustainable, and that ultimately his employment was in jeopardy. And this was clearly communicated to the griever in each instance. But the griever continued to believe that even if the absenteeism related to a medical reason, he wouldn't be terminated. So ultimately, at a certain point, in reviewing how often this griever had been away and the undue hardship analysis, the employer went ahead with terminating the griever's employment. Immediately after that happened, however, the griever sought a treatment that there was some kind of positing that it could have improved his attendance, and these were basically injections. But the evidence demonstrated that treatment had actually been available earlier, and the griever didn't really take any steps to try to see whether or not such a treatment was available prior to being terminated. So he didn't seem to really take it seriously. There was also evidence to show that even with treatment, there would still likely be some flare-ups and some attendance issues. So when this went before the arbitrator ultimately upheld the termination and found that, yes, the absenteeism was excessive, noted the operational issues and the undue hardship presented for the TTC. I think, and this is a running theme today, the griever, one of the biggest points to highlight is, again, the griever really didn't take any personal accountability for his actions. He seemed to be unapologetic of the fact that, his decisions to not come into work, both for medical reasons and otherwise, were posing a serious challenge for the TTC's operations. And he maintained the position even at the labor arbitration that, his family and his condition come first. So there was really no assurance that the griever took these actions seriously enough and would maintain regular attendance if he was returned back to work. So with that, we're going to look at some takeaways on disability. And these are reminders that, even if absenteeism is disability related, it can still result in termination if it's excessive. And again, there's no reasonable prospect of improvement. So again, when we're looking at termination, is that the only option that's left? If we were to put back this employee, is there any chance at all that we could avoid this recurring in the future? And then with these kinds of cases, it's so important to manage them. Getting the right medical information when you're dealing really with any kind of disability accommodation, so as to really understand the nature of the physical limitations and restrictions and how those interfere with the employee's abilities to do their job and the essential duties of their job. And it's important as well to, and as you saw, the TTC did very well in this case, to be very clear about the communications with the employee about, whether or not they are meeting the standards required for their position and if their employment is in jeopardy, because that makes it much easier later on to establish that they knew and would have known what would happen if they continued to participate in that kind of misconduct or behavior. And then lastly, it's important to see from this decision that the impact of an employee's absence on an organization is absolutely a relevant factor. And again, we want to think about that employee's role within the organization and their duties and how that impacts, right? So for instance, a CEO and the impact that might have versus a part-time retail employee who could potentially be easily replaced because there are any number of individuals who could replace that employee or take over for a portion of time. And again, remembering that managing persistent and periodic absenteeism can be a challenge. Our team sees these kinds of cases very often. They're very fact specific, in part because of what I'd mentioned earlier. Not all the absences are necessarily related to the same thing. And so it's helpful to have the guidance of counsel when you're trying to manage and parse all those difficult factual scenarios. And with that, I'm going to hand it back to Matt, who's now going to take a look at religion and vaccination.
Thanks, Louisa. So as I patiently wait for the day when I don't have to utter the word COVID during a presentation, we're not quite there yet. So we'll finish up today by talking about religious accommodation as it relates to COVID-19 vaccinations, but vaccinations generally. A lot of employers implemented vaccination policies, and if you heard any of our presentations or spoke with anybody on our team, you would have heard us say a key part of that vaccination policy would be to have an exemption for human rights code considerations, the two main ones being disability or religion. We weren't exactly clear. We weren't sure how the religion accommodation analysis was going to play out with respect to vaccinations because we didn't have a lot of guidance from the cases. We had an early Supreme Court of Canada decision that was unrelated to employment and vaccination that supported the position that the nexus to whether the objection from a religious basis can be established to an individual's personal beliefs, or if it needed to be established through a generally held tenet or a belief that was shared by other members of the faith. And so we sort of had the Supreme Court decision that said it could be personal. We had some other human rights decisions that said, no, the employee must be able to provide objective evidence that the belief is one shared by faith leaders and others in the community. So two recent cases we'll go through that explore this issue. And I would say, spoiler alert, they did not go the employer's way with respect to the analysis. So in the first case, Public Health of Sudbury and the Ontario Nurses Association, the employer implemented a COVID-19 policy. The griever was a public nurse involved in communicating with the public about COVID-19 and actually involved in providing vaccinations. She made a creed-based exemption due to Catholic faith. She was a member of the Latin Mass community, which is a subset. And she expressed that her concern was that fetal cell lines were used in the vaccine development. She requested an exemption. The employer denied the exemption on the basis that this was a singular belief about COVID-19 vaccination and not her faith. There was public comments from the Pope, for example, that encouraged Roman Catholics to get vaccinated. So the analysis here done by the employer was, this seems to be a singular belief, not tied to an objective belief of the faith, so they denied it. The union grieved, and in assessing the grievance, the arbitrator held that the griever must demonstrate the practice or belief has a nexus to religion or creed, and that the practice or belief calls for a particular line of conduct, and that this conduct does not need to be shared by other members of the same faith, and a personal connection with one's divine or one's spiritual faith may be sufficient. So ultimately, the arbitrator stated, once the griever learned about the fetal cell line connection with vaccines, even if that connection is factually and objectively quite remote, if the griever, right, bold, underline griever and not faith, if the griever sincerely believes that her faith does not allow her to get the vaccine, that would be sufficient grounds for granting her an exemption. Now, this was despite the fact that these factors existed that we have up on the slide here, some potential red flags about the legitimacy of or sincerity of her claim. So this was despite the fact that the griever had taken no steps to research if any other medication she had connection to fetal cell lines. So she wasn't able to demonstrate whether she had another vaccine or other medication that was similar to the reason why she was objecting. She had no issue in administering the vaccine to others, despite her concern about abortion and the fetal cell lines. And I think the sort of eyebrow-raising point for me is that last one, is that she initially claimed it was just general anti-vaccination position and not tied to religion. And it was only after that it was tied to religion. So I think if we were in person right now, I'd probably see some eyes rolling. I know that was sort of my first thought when I read this, but it's important that we're not dismissive of this, because I think this demonstrates to employers, how appropriate it is for us to take this seriously and do that procedural analysis that Louisa was talking about in the context of other things. Because on its face, it may not seem like this is a legitimate request, but the case law suggests that it actually may be, and that we need to take these seriously and assess them appropriately within the context of what they're brought. So despite this, the arbitrator was satisfied that the griever sincerely believed vaccination would be inconsistent with her beliefs and would amount to a condemnation of abortion. And so the grievance was allowed, and she was entitled to a religious-based exemption on the employer's COVID-19 vaccination policy. A similar case coming out of Nova Scotia. So again, in this situation, the griever was a nurse who refused COVID-19 vaccination on the basis of religious grounds. She was Protestant and member of the First Congregational Church. And in this particular case, she expressed concern that the COVID-19 vaccine was part of an evil plan to introduce the mark of the beast in society, which is essentially, she explained, was sort of like the end of times. And so the griever's church in this case supported member choice on vaccination, right? So they weren't as sort of overt as my comments with respect to the last case where we saw some public comments from the Roman Catholic Church, for example, promoting vaccination. Here they supported member choice. The employer refused the exemption on the basis that the griever was unable to establish a nexus to religion and that the church did not require or oppose vaccination. Therefore, this was a personal choice, right? Because they said, hey, you can be vaccinated or not be vaccinated. This was a personal choice and not one that was grounded in religious beliefs. Consistent with the public health Sudbury decision that I just went through, the arbitrator accepted that the griever herself had a sincere concern about mark of the beast, and it was a sincerely held belief by the griever. And the belief did not need to be reasonable or shared by others or her faith to establish a nexus to religion. So even in the absence of sort of the concern or belief being objectively reasonable from somebody on the outside looking in, and even in the absence of the fact that this belief was shared by others of her faith, the griever in this case was able to establish that there was a nexus to her belief. And ultimately, the grievance was allowed, and the arbitrator found that the rights under the collective agreement and Human Rights Act were engaged. But the question of how to accommodate the vaccine objection in a healthcare setting was remitted back to the parties, because that's a sensitive or an important issue for employers working in the healthcare setting. Is if we are obligated as a result of decision or a legitimate request that we believe is legitimate and allow an accommodation, how are we going to accommodate an individual in that setting? We didn't get any guidance from this decision. Ultimately, it was remitted back to the parties to decide. So some final takeaways here on religion and in vaccination. These are the first few decisions that we're seeing starting to trickle in. We expect that we'll see more cases on religious accommodation and COVID-19 vaccination. We've seen these cases from grievance arbitrators, but it remains to be seen if the Human Rights Tribunal adjudicators will take a similar approach or require evidence that belief is supported by religious leaders or community. There was some initial guidance from the Ontario Human Rights Tribunal, at least in a bit of a policy paper, that they may be leaning towards the latter, which is that it needs to be more than an individual belief, that it needs to be supported more broadly by religious leaders in the community. But we really won't know until we see it. And again, of course, we'll keep you posted with any decisions that come our way. And before we move on to the questions, we'll do a little shameless plug for the firm. If you've got any questions about your vaccine-related accommodations, feel free to reach out to any of us, and we'd be happy to speak with you and walk you through those. So with that, we are going to end the formal presentation portion of today and move over to the question and answers. And I believe my colleague, Louisa, will get us started on that.
Yep. So we have a number of questions that have come in. This first question might be my favorite. Do we have to accommodate an employee that will not return to the office because his circumstances have changed and he has 2 dogs to care for? And the reason why I love this question is because I think we've all certainly seen in the last couple years, pandemic puppies are a thing, and lots of people have definitely acquired fur babies in the last little while. So it's a fair question. And it's important to remember that family status in Ontario really relates to that parent-child relationship. So a caregiving role with respect to a parent or a child, and unfortunately doesn't extend to fur babies, as someone who also has fur babies. And so as such, that duty to accommodate really doesn't extend in the same way that it would to childcare obligations. The next question that we're going to look at is, what are your thoughts on suspending an employee pending investigation based on sexual harassment allegations by another employee? And suspending an employee is definitely something that's available to an employer during the course of an investigation. However, you want to be mindful of that piece of whether or not you're suspending with pay or without pay. If you're suspending an employee without pay, that can be seen as a disciplinary consequence that flows before any real investigation has occurred, and really before the chance for any of those findings to be made as to whether or not the complaint was substantiated in the first place. So what might be more advisable is to consider suspending the employee with pay. And particularly, that might be appropriate if there's a concern about the nature of the workplace. So thinking back to kind of one of those decisions that dealt with a smaller office space and what it might have looked like to keep that employee in the office working with the complainant during that time. So kind of thinking through those dynamics is helpful with respect to whether or not to suspend the employee pending the results of the investigation. And the third question I'm going to look at now, it asks, is the employer not required to warn the employee first before termination? Is this what happened in these sexual harassment complaints? So just to take a step back here for a moment, it's important to remember that a finding of sexual harassment can be made in instances of multiple interactions of sexual harassment. But if there's a single incident that's very serious, that on its own can amount to sexual harassment, and there really wouldn't be an opportunity to warn in that kind of a scenario. And so it's very fact specific, and it depends on how egregious the sexual harassment is. Thinking back to, let's say, Husko, that first decision that we explored, if you recall, the employee in that case was actually warned that his conduct was sexual harassment. He just didn't want to accept it. So, I mean, he accepted the sensitivity training, but just didn't want to go that step further to apologize. So in that kind of a circumstance, the employer really had no choice but to move forward with the termination. Matt, did you want to speak to any questions on your end?
Yes, for sure. So we've got some great questions here for me to look at. So the first one is, can you comment, if possible, on implicit bias in hiring decisions? Is there a way to prove it? So the starting point for this analysis, for those of us who may or may not be aware, is that a human rights code through the provinces provide protection to an individual from the very beginning of the employment relationship. And this includes even like a job posting or job advertisement, and through the hiring process. And so when we're talking about potential implicit bias in hiring decisions, adjudicators are going to look at circumstantial evidence to support a conclusion that a decision was discriminatory, right? So very rarely, particularly in these circumstances, are we likely to find, like a smoking gun, like I referred to earlier, or some overt act of racial discrimination. But what would happen here is, in order to, if an applicant wanted to prove it, is what the tribunal or a labor arbitrator would look at is whether or not the incumbent, so the individual that got the job or was awarded the job, was less qualified than the employee that was alleging discrimination. So when we look at objective factors, right, was one objectively a better candidate than the other? Were there any comments made during the hiring process that potentially demonstrated that the employer was considering a protected ground? So, for example, oftentimes when we're just chatting, right, and we're sort of trying to get comfortable with somebody, we may ask a question like, oh, do you have children? And it may seem like an innocent question, but ultimately, if the answer is yes, I have 3 young children, and that person is unsuccessful, and the job, for example, requires travel, or maybe unpredictable hours, that person may associate the fact that they did not get the job because they volunteered or answered the question that they had young children. So if there's not going to be that smoking gun, the decision makers will sort of look at some of that circumstantial evidence. So the best thing that we can do in our hiring decisions is try to point to objective reasons for why somebody was the better fit and ultimately hired. Next question, which was a great question. So who has the burden of proof in racial discrimination cases, right? And I think we can even sort of broaden that question to say, who has the burden of proof in discrimination cases? So as a first step, the employee has a burden of proof to prove that they have a prima facie case. So what they have to do is the employee has to demonstrate that they're a member of a protected group, right? So either it's race, family status, disability, et cetera, that they were subject to adverse treatment, right? So demonstrate that they were treated differently. And then the last piece is that a membership in that protected ground played a factor in the adverse treatment, right? So again, an emphasis on a factor and not the main factor. It just has to be a factor. If the employee is able to prove those three things, then the burden shifts to the employer to demonstrate a non-discriminatory reason for their conduct, or that it was a bona fide occupational requirement that can't be accommodated. And I'll maybe take one more question before I flip it back to Louisa. The question is, are a lot of human rights cases filed by unions, or is it mainly just filed by individuals at the Human Rights Tribunal? So the answer in Ontario for sure is like you see a bit of both, right? So oftentimes we see them through the grievance process, which are brought by unions. But in Ontario, at least, we also see human rights claims filed by individual employees, whether it's a unionized workplace or not. I don't think we can, I don't think I really have a real answer one way or the other, which one we see more often. What I will say is sometimes it's easier to deal with when it's brought through a grievance because you have somebody, often a union or a council who's acting as their representative versus oftentimes when it goes through the tribunal and if somebody's represented by the union, like they've made a decision to advance that on their own. And oftentimes, I can't tell you the amount of times we've gotten like a 15-page sort of handwritten complaint at the tribunal that goes through every single wrong over the past however many years through their employment relationship. So it can go either way. And as discussed in Ontario, we still see claims in both. But if there's anything changes as a result of the Horrocks decision, we'll obviously let you know.
Just before I get to the next few questions, I do want to go back quickly to one of the questions, just to briefly note with respect to the question of whether or not to put an individual on an unpaid leave or a paid leave pending investigation outcomes. Just to remind employers again that language is important and it should be called an administrative leave with pay rather than a suspension with pay. Again, just to avoid any kind of argument later on that this could be seen as disciplinary. So with respect to the next question, the question asks, does the ESA family caregiver leave or any of those types of leaves apply when the family member requiring the care is out of country? So this is a family status question, and it's a great one because, as you know, under the ESA, there are a number of different kinds of leaves that could apply in this context. But it's important to remember that the thresholds and the criteria for what might be considered for eligibility for ESA leaves is slightly different than what we look at from a human rights accommodation lens and from that standpoint. So the ESA related leaves really don't specify that the family member needs to be located in Ontario or Canada. They don't require that. But if the employee is able to provide the documentation or the information necessary to justify the leave, and often that's to establish that the individual that they're seeking to help or guide or aid really needs necessary care, that employee might be entitled to leave to accommodate their situation to provide family care for a family member in another jurisdiction. The next question is also a family status question. It asks, what types of documents can we request in family status requests? And how did the employee provide proof that family members could not watch her children? So this is a good one. Realistically, in many cases, we really kind of end up having to take an employee's word for what their family members can or cannot do, or whether or not someone is able to care for their child. But there's certainly room as an employer to push back a little bit and to ask for documents. We saw that in one of the cases, right? So for instance, if the employee is saying that they just don't have room to be able to sign up for, let's say, after school care, asking the employee for the wait lists associated with that after school care program, looking at the costs, as we saw in that decision, of what it might look like to provide transportation or for those services. Those are all reasonable requests. And really with respect to all family status accommodation issues, they're very fact specific, and it really just depends on the nature of the alternatives that are being explored. And so another question on family status, this one's hot today. So both family status cases appear to suggest that employers have a de facto obligation to accommodate employees' personal decisions as to whether or not to use third-party childcare services or to accommodate the other parent's own professional choices and obligations. Did any of these decisions address that point directly? So I don't think the cases necessarily go as far as to suggest that the employees didn't have to use third-party childcare. And recall again that the City of Toronto case did actually note the fact that the employee had failed to consider babysitting options. So really, when we're looking at the question of self-accommodation, even though there isn't that requirement for an employee in Ontario to exhaust self-accommodation prior to establishing a claim of discrimination, it's certainly a relevant factor in the analysis. So if there are reasonable options that are available to an employee, it can definitely inform the fact that, you know, the employee failed to consider those things, which makes it look more like a preference and less than a need for whatever accommodation alternative that they're seeking. And Matt, I have one more. I don't know if you wanted to take the next one or if you have.
Sure. Why don't I jump in with a couple questions, because lots of great family status accommodation questions, but we do have a question about my jurisdiction case, Horrocks. So I'm happy about that. Question is, how does Horrocks impact the federal jurisdiction? And so the comments that we saw in that case really distinguish the language in Manitoba from the legislation in the federal context and in the context of the British Columbia legislation. So it was quite Manitoba specific, but the comments in that case and the commentary from the Supreme Court suggest that the federal jurisdiction will continue to be a concurrent jurisdiction model. So continue as it is, which is either through the tribunal or through a grievance procedure. I also have one more question here along the same vein, similar topic. If someone is unhappy with their grievance outcome, can they take it to a human rights body? And that's a great question. And so the Human Rights Code provides the tribunal with jurisdiction to dismiss a complaint if the substance of a complaint has been appropriately dealt with by another proceeding, right? So if we feel like if somebody has filed a grievance and they're not happy with the result, they can still try to file a complaint, but the tribunal can dismiss it if it's been appropriately dealt with. And the concept or the idea behind this is to avoid a duplication of proceedings. So we don't have two different administrative bodies hearing the same issue twice. The test for appropriately dealt with isn't a right of appeal. It's really an assessment of whether the human rights issue has been considered in the other proceeding, right? So as such, if an employee tries to go to the tribunal because they don't like the arbitration decision, there's a strong likelihood that the complaint is going to be dismissed. So certainly if you find yourself in a scenario where somebody has raised a human rights issue through the grievance procedure and it's been dealt with, and then they try to come through and file one with the tribunal, either with the support of the union or with not, you should absolutely be looking at objecting on the basis that it's already been appropriately dealt with and the tribunal doesn't have jurisdiction to hear it.
Back over to me. So now we're looking at disability. And this question comes out of that last TTC decision that I'd walked us through. The question asks, did the TTC employee for the disability case receive termination and severance pay? Which is a great question in light of the other cases that we looked at. So under the Employment Standards Act, there's actually a provision that entitles an employee to termination and severance pay if their employment is frustrated when the frustration relates to disability. So in this case, yes, the griever was terminated for innocent absenteeism, and that's essentially what we call frustration in the unionized environment. And so that's why this employee was entitled to those amounts for termination and severance. And Matt, I believe that's all the questions on my end.
Same with me.
Great. So on that note, that brings us to the end of today's program. We hope you found it informative. And just a reminder that the video and the slide deck will be on our website in a day or so. If we didn't get a chance to answer any of your questions or any single question that you really particularly wanted answered, please drop us a line. Don't hesitate to reach out to any one of us on the team. We'd be happy to address it for you. Our next HR review webinar will take place on Wednesday, December 7th. and the topic is in the design phase, and we'll send out an invitation in due course. If you're on our mailing list, you'll receive an invitation. And if you're not yet on our mailing list, but would like to receive our briefing notes, newsletters, and invitations to seminars and workshops, much like this one, please subscribe through our website. It's that big red bar at the bottom of every page. Finally, we'd be very grateful if you'd fill in the feedback form that's going to pop up on your screen once this Zoom webinar is closed. Thank you again for joining us, and we hope you have a great day. Bye, everyone.